Hello, and welcome to this short guide for people who've been asked to give evidence in a criminal trial in Scotland. Now, your journey to giving evidence begins really with the citation. Usually, this will arrive in the post, and it will come from one of two parties. First, either the Procurator Fiscal, who is a qualified solicitor who works for the Crown Office, or a defence solicitor acting for the accused. If it's been sent by a defence solicitor, it is unlikely to be someone who works here at the CLO, simply because we do not really deal with any criminal matters. We are, of course, always on hand to provide advice or assistance, however, if appropriate. Now, there are a number of reasons why you may have been cited to attend court as a witness. You may have relevant information about a criminal case. You may have been the victim of a crime. You may have seen or heard something in connection with a crime, or you may have some information about somebody who is accused of a crime. The citation itself will usually explain what type of court case it is, either criminal or civil, the dates that the trial is sitting, the entire dates, where the court is, how to get there, and how to claim expenses for your attendance at court. The first step you should do upon receiving a citation is to have a conversation with the solicitor who sent it to you. You'll need to liaise with them to confirm which specific date you have to attend, and you may be asked to provide your availability in case you've already booked any holidays or you're unable to attend certain days that the trial is sitting on. Now, when you're preparing for your appearance, you should familiarise yourself with any documents that you think you may be referred to or asked about. Read over any statements you may have given to the police or anyone else, and if you don't have copies of anything, ask the solicitor who cited you if you can be provided with it. They may not let you see everything, but they will keep you right. Once you arrive at court on the day that you're giving evidence, first things first, check in with the front desk. Give them your name, the name of the trial, say you're a witness, and it'll probably be helpful to give them a copy of the citation if you can bring it with you. You'll then be taken to a witness room, and you'll wait here until you're called to give evidence. And you can normally bring someone with you for support or assistance. They have to stay behind in the witness room, but they can wait in the room with you as long as there's space. And you may end up waiting in the witness room for a number of hours, possibly all day. Depends on if the witnesses ahead of you have ran on. There's always a possibility it may run on into the next day, especially if you've not arrived until the afternoon. It's not a bad idea to bring a book with you just to help pass the time. But if it's any help, witnesses for the prosecution and for the defence are kept in separate rooms, so you will not cross paths with anyone on the other side. Now, the solicitor who cited you will come to meet you in the witness room, either before court starts in the morning or after it resumes, after lunch, depending on what time you've arrived. They will give you an update on how matters are proceeding and when it is likely you'll be called. And when you are called to give evidence, simply follow the court officer who will come and get you from the witness room, and they will take you to the witness box in the courtroom. So it might be helpful to go through who is likely to be in the courtroom when you're there. So the following people: we've got the judge, and the correct terminology when you refer to them is either my lord or my lady, depending on if they're a man or a woman. There's the clerk. They sit in front of the judge and they handle a variety of administrative matters. You've got in front of the clerk your legal teams. You've got legal team for the prosecution, who will likely have a procurator fiscal, possibly more than one, as well as an advocate depute. And you'll have the defence legal team opposite them, which will likely include a solicitor and a criminal advocate. You'll have the accused, who's in the dock, and in certain cases you may have a jury off to one side. Now, you'll also see a number of people kind of dotted around the court. There's various court officers, police, security officers, etc., who are there as well. But those are the main players, official players. But of course, most trials are open to the public, and there may be a gallery in the courtroom where members of the public over the age of 14 can come and sit and watch. And depending on the case and the nature of it, there may be members of the press there as well. So, once you've entered the witness box, you'll be required to swear either an oath or a non-religious affirmation that you will tell the truth. And once you've done this, you're then ready to give your evidence. So, how does giving evidence actually work? Well, it's taken in the form of questions asked by both sides of the case. Now, the side that cited you, either the prosecution or the defence, they get to question you first. So questions will begin by asking your name, your age, your qualifications, your job title, your experience, and so on. We're really just setting the scene here and showing the court why you're able to give evidence and why this evidence is relevant to the case. Once that's out of the way, questioning will then move on to the case itself, and this is what we call examination in chief. It consists of mainly open questions which allow you to give full answers. So think things like where, when, why type questions, ones that really let you open up and give a full answer. Once that side is finished, questioning moves to the other side, and this is what we call cross-examination. Now, this largely will consist of closed questions, and unlike open questions, as they sound, they're more focused on providing shorter, more specific answers. Once this is done, it may move back to the other side again for what we call re-examination. This is a final set of questions, and it's limited purely to matters that were raised during cross-examination. And the aim here is to allow you to provide some of the clarity to those closed answers that you gave in cross-examination and kind of open them up a little bit, fill them up a bit more, give more kind of background. So, starts off with one side doing open questions for examination in chief, where, when, why questions, full answers. Then other side, cross-examination, closed questions, shorter, succinct answers that they're looking for. They're trying to get you to say one specific line or one thing. That's what they're trying to drill you into. And then it'll go back potentially to the other side again for re-examination, who will then ask you issues that you raised during cross-examination and allow you to add some meat to the bones of those closed questions that you answered during cross-examination. Occasionally, the judge may interject, may ask some questions themselves. That's completely normal. And when you're giving your evidence and when you're speaking in court, there's a few things to keep in mind. The first of which is answer truthfully, obviously. Try to remain calm. Remember to breathe. Listen carefully to the question. And most importantly, only answer what is being asked of you. It's easy to become flustered and stressed, and there's a real temptation to wander off piste, allow your answer to ramble into a different area or off course. Don't feel you have to answer the question immediately. Just take a moment, take a breath, consider your answer, and keep your answer succinct and to the point. And if you don't know the answer or you don't understand the question, then just say. It's fine to say you don't know the answer to a question. Stick to the facts, stick to the knowledge that you have. Do not make any assumptions. Do not be drawn into speculating or into a hypothetical discussion about what might have happened, which may well be incorrect. If you don't remember what you did, because let's be honest, most of this stuff is happening a few years in the past, it's likely you may have forgotten certain things. If you don't remember something, that's fine, just say so. And you can sometimes point to what your usual practice would be and say, well, I don't remember this specific example, but my usual practice is to do X, Y, Z. That can sometimes be quite helpful. And remember that the judge or the jury, if present, they're ultimately the decision makers here. So when you're giving your answers, speak loudly enough that they can hear you and slowly enough that they can note down your answers if they want to. Be prepared to explain any jargon, any technical terms or technical language which they may not be familiar with. And try not to react emotionally. Try not to appear impatient or patronising. Don't be aggressive or argumentative. I think doing any of that stuff just really harms your evidence, and it may serve to discredit the answers that you're giving. So keep it calm, take a breath, and just answer what you can, and don't be scared to say you don't know something. Depending on your involvement, as we said earlier, your time in the witness box can last for several hours. There will be regular breaks throughout the day, but it can be quite a stretch depending on what you're being asked about. Once you've finished giving your evidence, you will be free to go. You should not return to the witness room at this point, and you should not discuss the evidence you gave with anyone else involved in the case, especially those who have yet to give evidence, because they may be influenced by what you've said, and that's a big no-no. You may want to sit in the public gallery once you've finished giving your evidence and listen to the rest of the court case. That's absolutely fine. And the judge or the jury may not be able to reach a decision straight away when you're finished. There may be other witnesses to give evidence. There may be other statements to be given. Some cases can take days or longer, so don't worry if you don't hear straight away the outcome of a case. In a criminal court case, you are entitled to ask for more information about the final outcome of a case. So if you want to know what happened in the end, you're always able to find out. And finally, in terms of extra support, I would direct you to go to the mygov.scot website. It's got a lot of resources available there about being a witness at court. It covers topics such as citations, what to do when you arrive at court on the day. It outlines a lot of the special measures that can be put in place if you are a vulnerable witness, or if you have specific arrangements such as wheelchair access or a loop system if you're hard of hearing. I think most citations should have a link to that mygov.scot website, but you can find it online. It's a very useful website to have a look at. And it also, finally, outlines what the court calls the Witness Service Programme. Now, this can arrange for you to attend court before the trial starts to give you an idea of what to expect. And really, I think going to attend court yourself before you're due to appear is probably the best piece of advice I can give you. Go there before you're due. Go up to the front desk, say you're just here, you want to see a case, ask if there's anything interesting on. They'll send you to a courtroom, have a seat in the gallery, and just spend an hour or two and just watch the court. See how the questions are being asked and answered, what's coming across well, what's not, see the order of things, get a feel for the atmosphere in the room. That's probably going to do you much more good than watching a video or reading about it. So I would strongly urge you to go in advance, if you can, to watch it. It will be very helpful. But apart from that, I hope this video has been very helpful. Thank you very much.